Yes, welcome to the No State Project live from the fortified compound here in Mesa, Arizona for August 17th, 2019. Glad to be with you here as people start to file into the big show. I do want to say a big thank you. How is that possible? Just a big thank you for the continued support of the big show. If you want to be able to help support the show, it's markstevens.sells.com. That's SELZ, markstevens.sells.com, and markstevens.net. And Flat Earth, there's actually an interesting video that some flat earthers put up recently. And I think there's even a documentary that goes into a lot more detail where they were doing an experiment to prove that the earth was flat and wound up proving that it was in fact curved. So it had something to do with the with light. Pretty funny to watch. So I really don't get how people can believe that the earth is flat considering how much evidence there is. But welcome to the show here. We've got a lot of stuff to get to. If you want to join me, and I'll give this out again later when I'm actually going to be taking calls. But if you want to get into the queue, it is 218-632-9399, 218-632-9399. The passcode is 2020 and the #. You can also reach me on Skype at Frank Rizzo 3. Do not use the Frank Rizzo 3 to just call me. But if you want to be on the show on Skype, actually, I can't. You're going to have to just use your Skype and call 218-632-9399. But you can post questions to me and concerns or comments on Skype. You can also, of course, put them into the YouTube chat. Someone's saying the documentary is a hit piece, and I'll send you a link for a proper documentary. All right, I'm not. I don't know. I don't get it. I don't get it. I don't get it. I actually had someone call the show who I think it was the guy who got heard trying to use a rocket in an effort to prove that the Earth was not round. So I don't know. But yeah, I'll look for that link. Hit piece. Okay. Let's see. Yeah, again, appreciate everyone's continued support of the show. Of course, Dan and Bill in New Hampshire, Eyal and Chris in California, Nelson. Appreciate everyone's continued support. Don and Marc. Much appreciated. And if you are looking to, learn how to effectively defend yourself, if you are in the lines, then that they have forced you to participate in a little in a charade of a trial. Go to markstevens.net. Adventures in Legal Land. Well, obviously, Government Indicted has a complete map or model that I and others have used to successfully defend ourselves against these baseless attacks. And also have scripts and motion templates available. And speaking of, before I get into how prosecutors can lie with impunity, and yeah, monetary fine against the office is still lying with impunity, because if I was to lie consistently to a federal judge, do you think that they would just hit a monetary fine that doesn't even affect me personally? No, I would be thrown in jail. But we'll get to that. But considering another federal prosecutor who could do literally whatever he wants and get away with it, Alexander Acosta has still not to this day been questioned on why he went so easy on Jeffrey Epstein, given the overwhelming evidence that was that they had. And we still don't know who the co-conspirators are beyond Giselle Maxwell. So sweetheart deal for child trafficking, Alexander Acosta. And this is the thing, no matter what comes out, no matter what evidence comes out against Acosta, he's not going to do any time. He will not be charged. He will not be punished. He will totally get away with it. So, Mark, I just got the second judge to recuse herself. Do I need to file all new paperwork? All right, well, yeah, if the judges made rulings against you and they were arbitrary and capricious rulings and they've now been recused, then yes, I would refile the paperwork and include in there the prior judge did do the right thing eventually by recusing themselves because of the obvious bias and prejudice, and because the rulings are arbitrary and were based on prejudice against me, they should be reheard. So, someone saying, speaking of corrupt prosecutors, Kamala Harris. Yes. Kamala Harris is, just a typical career prosecutor. And here she's putting dozens or hundreds of thousands of people in jail for marijuana possession, and she smokes pot herself and admittedly smokes pot. I think she was actually caught laughing about that. So yeah, Kamala Harris. Yeah, that's most of these prosecutors. Fit the mold of a Kamala Harris or an Alexander Acosta. When you have a real actual criminal, like a police officer or a child molester, hey, as long as they got the connections or they got the money, no. But you get one of the plebes, you get one of the little people like you and I, and you have a little bit of herb, boy, they throw the friggin' book at you. So what I mentioned last show, that this federal judge in Kansas, Julie Robinson. Now, this is the result of over a 2-year-long investigation holding an entire U.S. Attorney's office in Kansas, that Kansas district, holding the entire office in contempt, which you would think, hey, they're holding the prosecution responsible. No. There's a monetary fine against the office, which goes to their budget. It doesn't affect the prosecutor's day-to-day at all. It's if I'm caught, I don't want to. She wrote, employed a wholesale strategy to delay, diffuse, and deflect during a 2-some-odd-year investigation. Every step of the way, practically, they resisted. They wouldn't comply with subpoenas. So she found him in contempt. And unfortunately, that's probably as far as it's going to go. So that's why I say they can lie and commit prosecutorial misconduct on a major scale, and nothing. You're talking about actions that if you and I took, we would go to jail. So if she held us in contempt, you go immediately to jail. You ask a question, you can go to jail for 6 months if you're one of the plebes. But if you're one of the king's men, if you're one of these prosecutors, you can literally do anything and not go to jail. There's nothing you can do and not go to jail for as long as it was on the job. There's only one prosecutor in American history, Ken Anderson, one single time of a prosecutor going to jail for obstruction of justice and prosecutorial misconduct. One time. And it wasn't even prison, it was jail. And it was less than 2 weeks. So yeah, I think I've got a Everest-sized mountain of evidence to show that prosecutors never are held to any kind of responsibility for the crimes that they commit. Oh, but Mark, they got disbarred. Disbarred is not a criminal proceeding. I have been threatened with contempt, and I've had people call the show when we have Terry in Michigan. You ask a question, you go to jail. Someone tell me, why can these prosecutors, as an office, as a conspiracy, commit all sorts of felonies and they don't do any time? So to give you an update, this is from a case called U.S. versus Carter out of the Kansas District Court. And what these prosecutors were doing, see, Tomasic, and there's another one, Flanagan, which were just two of the ones that were named in here. They were recording attorney-client discussions and meetings. Wow. Wow. And what they brought out in this is that the prosecutors were then able to take that information, because in one particular case, this individual was going through several other court cases that she was talking to her attorneys about. They're talking about intimate details and strategy. And these prosecutors took this information, took these statements, and then turned around and used it against them to pressure them into plea deals. It's bad enough that you're stuck in jail. It's bad enough you have to use a member of the bar because they're the only ones that are permitted to allow, to help you. Oh, because they're shining examples of ethics. And despite that, you have another set of lawyers who are taking your personal privileged information, statements that you gave in confidence to your lawyer, under the impression that it was privileged and it was private. And then they used it against you. Now, if you can go to jail for 90 days in Michigan and other places for asking a lawyer a question, why is it that these lawyers, these prosecutors, can, as an office, conspire against defendants to violate their attorney-client privilege, to violate their supposed right to a fair trial, and do this to at least 380 known defendants? You're talking RICO here. How is it possible for them to get away with all those felonies? And it's in the judge's face. They don't do any time. Not a day. Not even, hey, why don't you put them in the tank for a few minutes to maybe they can think about nothing. Nothing. So what the judge does is detail how throughout the investigation, they were supposed to really, provide discovery, and they were supposed to provide evidence, and they were supposed to, there was an order that went nationwide to the U.S. Attorney's Office. None of them were supposed to destroy or delete any hard drives or any of the recordings until at least after the investigation and the judge rescinded the order or changed and modified the order. They still destroyed evidence. That's obstruction of justice. You're talking it's systematic. You're talking about the grunts and management involved with this. And they lied about it. There's another felon. You're talking gross obstruction of justice by these prosecutors. Nothing. They may have civil immunity, but they don't have criminal immunity. There's no reason why they can't be indicted other than who's going to do the indicting? More corrupt prosecutors. Again, if you lie to a federal judge, you go to jail. But if you do it as part of the team called the U.S. Attorney's Office, nothing. So one of the things she mentions here, it's something that doesn't always come out. And it wasn't really reported this way. They said that okay, so the human aspect to this, to really see, this is not just, it just seems to be not a part of the conversation. And you have to look at, these people are in jail. They're in They're in jail. They're in a federal prison waiting for trial. And the judge at least mentions here, the Black investigation will soon reach the 3-year mark. Over 100 habeas, this is a Section 2255 litigants, it's a habeas corpus, continue to serve their sentence without the opportunity to present their Sixth Amendment claims, due in part to the government's tactics and delay. We're talking obstruction of justice. We're talking about dishonestly and corruptly interfering with a federal investigation. They talk about law and order. Oh, Kamala Harris, law and order. But that doesn't apply to them. They obstruct and delay every single step of the way. And instead of the judge ordering the entire office into prison, it's a monetary. We'll hit the office with a small fine, which they don't pay. You and I do. These people are sitting in jail, and the prosecution is still fighting against having their indictments thrown out. Well, that's such an extreme. Well, let's see. Are there extreme conditions here? You have an entire office of the U.S. Attorney's office. The entire office was held in contempt because for over 3 years they obstructed justice. You know, if you don't throw out the indictment, I would say, fine, indict all those prosecutors. In fact, I don't even want to see that. Avoid the whole thing. The judge has the evidence. They've already had evidentiary hearings over the course of 3 years. They have all the testimony that they need. The judge has already held them in contempt. All the judge has to do is order them to do, let's say 364 days in jail. Every single one of them. But they're not going to do that. And as anarchists, we know exactly why. Because they're part of the ruling class. And they can do whatever they want. So I don't see any, thank goodness, but some dissent is cool, but I don't want to see the usual trolls, which is nice. They've been gone. It's nice. The number of the views on the videos are going up, getting more subs, and the trolls are gone. So that's a win all around. But I don't see any critics posting that the U.S. attorneys are good people. Oh, it's just a couple. It's not just Tomasic and Flanagan. The entire office was held in contempt. Yeah, I tell you, I have the. I will have the entire case, the decision of the Judge Robinson. I'll put that again in the show notes, and I'll post it now in the chat, so anybody can just go look that up and read it. It's some dry reading, but when you go through this, and they're giving example after example after example of these felonies committed by these prosecutors, you can't help but want to just grab the judge by the throat. Why aren't you doing something about it that will actually have an impact? Can you imagine the impact that would have if a federal judge threw an entire office, the U.S. Attorney's office, if they threw them all in jail for even if it was just 90 days? You don't give these pricks an opportunity to prepare. Just like with us, they just haul you off, treat them exactly the same. Imagine the impact that could have with other prosecutors. Like, oh my gosh, there's actually a judge out there applying the law to us. Every one of them, at the very least, should be disbarred and have assets seized to cover the cost and what they've done. But just like with Alexander Acosta and those who were involved as co-conspirators with Epstein, nothing is going to happen. Nothing. So anyway, if you want to join me here on the big show, it's 218-632-9399. The passcode is 2020 with the pound sign. I'll get to the calls here. If you want to discuss anarchy, government abuse, like I was just talking about, U.S. versus Carter, or defending yourselves against these vicious, vile attorneys. This is why Judge Alex Kaczynski, he was right, and he had the evidence to prove it. Prosecutorial misconduct is at epidemic levels, and only judges can put a stop to it. And here, Judge Robinson had a perfect opportunity. Talk about making a name for yourself. She'd go down in judicial history for putting a whole office of lawyers into jail immediately for contempt. But that's me. They would be teaching that in law school. Every time a new crop of prosecutors came in, they would be talking about this Judge Robinson. Like I said, like, look, most judges are going to let you get away with as much obstruction of justice, as many dishonest things as you care to do. But there's going to be a chance that there's going to be a judge out there like Robinson who's going to throw your butt in prison. So, no, nothing's going to happen. But regular listeners to the show, we already know. That's why we're anarchists, because we know the ruling class is not going to hold itself accountable. The rules don't apply. But we got Mac from BC. Welcome back to the show. We having an issue already? We got Mac?
Hello?
Yeah. I can't believe this. I tested everything. I still have my...
Can you hear me?
Yeah, I can hear you.
Okay, sorry, I was working and I had the phone off. Perfect. That's perfect timing by me.
Yeah.
So, what was I going to ask you? So I got to go to Idaho, deal with a prosecutor, I guess, for the first time. I sent the motions in by email to the prosecutor. They said that's fine. And I faxed a copy to the court of the motion to dismiss and the discovery request. So I'm not familiar with the American process. I've been through the ringer several times up here in Vancouver, Canada. So I'm just wondering, what can I expect to happen here, getting closer to the trial date?
When's your trial date?
September 20th.
So how long ago did you file the paperwork?
Yesterday.
Oh, yesterday. Okay. All right. We wish you would have done it sooner, but they have at least about 21 days to respond to the paperwork. So what you can expect most of the time is you hear nothing, and they may address it, and they should address it the day of trial. In very limited circumstances, do we hear where the prosecutor files a response to the motion to dismiss. And what you can expect there is they're just going to slam you, and they're going to use they're going to say it's frivolous, and they may even label you a sovereign citizen or freeman on the land. They won't actually address any of the arguments and the lack of evidence that are the main part of the motion to dismiss.
Okay. So if I show up in Idaho and the cop's not there, are the chances they're going to dismiss pretty good, or will the prosecutor go ahead without, or will they try to go ahead? Or can I expect small town Idaho for the cop to show up?
Very rarely it's more as a place like California where if the cop doesn't show up, they give him a free pass and they will reset it. Most of the time the cop doesn't appear, it's thrown out.
Okay.
Yeah, but you got to prepare as if he's going to be there, obviously.
That's what I'm planning to do. So just to backtrack a little bit, I know I've had hell going on in my life. That's why I didn't file it. And I was supposed to do it when I went down to the States, but I was in Montana and actually had no cell reception or access to internet. It wasn't what I expected. So I got back, was swamped, and then finally I got it all sent in yesterday. But let's just say I had done this 2 or 3 months ago. Then what could have happened after the 21 days? Would they have sent me what I asked for, or would they have just been like not sent me what I asked for?
Well, they're going to send you some. Typically,
Okay.
what would happen is they may give you a copy of the police report, and they may give you a copy of the cop's notes. Will they give you a copy of the front and back of the police officer's original ticket? Probably they will resist that because it's been shown that they write notes on there, and so it's ex parte communication with the judge, and that's a big no-no. They are never going to, in my experience, they're never going to be forthright and honest with us and admit that the witness that they are going to call against you does not have personal knowledge to the matters they're testifying to. So that is exculpatory information that they are required to give you, but won't. It's not called Brady up in Canada. It's just exculpatory evidence that they are still required to give you, just like in the United States. But they don't. They don't. If anything, they will come out and say that the witness they're complaining to testify that the laws apply and you violate. They'll give you the name of the witness, but they're not going to answer whether they have personal knowledge of it. In fact, there's no way, because they actually, and one of the things that they don't give you is they don't give you the actual proof they plan on using to show that they do have personal knowledge. So that's some of the information that they don't give you, which is discoverable material. I mean, it's something they have to give you, but they won't. So
Sorry, go ahead.
Well, in those instances, then I would file the motion in limine and the motion to dismiss for prosecutorial misconduct.
Okay, I've got, I'm not sure if I have those for Idaho. I haven't heard of this motion for prosecutorial misconduct. Now, when I go to court, do I start objecting? And it's what I'm gathering from everything I've listened and we've talked about before is I should start objecting and asking for the judge to rule. I got to get him to rule on the motion to dismiss, I guess, before anything.
If he hasn't ruled on the motion to dismiss, then absolutely. All the pretrial motions should be ruled on prior to forcing this matter into forcing you to participate in the trial. So yes, that's what if you don't object, chances are they're just going to ignore your motion completely. So you definitely are right. You want to object and say that there's a motion to there's pretrial motions that still need to be determined. Now, be aware that one of the lies these people will tell is that a pretrial motion is something that the judge can reserve to ruling on until after the trial. Well, I mean, come on. It's called a pretrial motion. It's in the name, people. That's just a lie. I'm going to reserve judgment on your motion on your pretrial motion to dismiss until after trial. No. We even had one in Ohio say that when he was questioned, is there evidence on the record to prove jurisdiction? And he says, well, that's what we're here. He says, I don't know. We're here at trial to determine that. I'm like, you don't push something to trial unless there's evidence in the record proving jurisdiction. But these are some of the lies you should be familiar with before you go in there. But you should be assuming Mac, that everything coming out of the judge's and prosecutor's mouth is a lie anyway. And your job is to object and get them to verify what they're saying.
Now, another fear I have is because I'm a foreigner coming in, that they're gonna try to, strong arm me and bully me, because I'm not an American. Have you had any experience with anybody not from the U.S. having to go defend themselves in small town butt fuck United States?
Hello. Okay. That sounds like Larry Craig area, but they bully pretty much everybody who's not a part of the ruling class. Everyone gets bullied. So, do you look like an American? Do you look what the average American would look like?
Not really, but brown skin with a mohawk. So
wow. Well, the brown skin is definitely going to be held against. Could be used against you in a place like Idaho, which is what? Can I ask you what little town in Idaho?
It's Jerome. Just close, about 3 hours, I think, from Boise by Twin Falls, Idaho, just on the other side.
Could you say the name
Twin
of it
Falls,
again?
I think the river. Sorry?
Did you say Burley?
Jerome.
Oh, Jerome. Gosh, I really screwed that up. Okay. Well, I'm sort of familiar with the area because I had family that lived near Twin Falls for a while. But no, I don't think that that's something what may work again. The way you look, I don't think necessarily work against you as far as the bullying and whatnot. I think what works against you is if they know that you are so far away that they could bully you more because you may not want to come back for another hearing.
No, of course not.
I think that's.
So do I argue undue burden if that happens, if they try to delay it?
You certainly, yeah, absolutely. You could, because it's an undue burden, certainly you could file and it's called to have it heard telephonically. So even in Jerome, as far as I know, it's still 2019 in Jerome. So they probably have the electronic capability to do it telephonically. They don't like to do it though. It's not, their threats don't carry the same punch when you're on the phone as when you're right there.
Okay. So yeah, because I'm thinking like, if they're trying to get a delay or something like that, a continuance, then I can argue undue burden. I think you were talking about that in one of the last couple of shows. That's a legal term. See what the judge says to that. It's a female judge or magistrate. I have no idea what they call them.
Judge, magistrate, same thing, basically.
Is it?
Yeah, okay. Pretty much the same thing. It always comes down to someone in a robe is forcing you to participate in a sham called a trial. So you may call them judge, justice, magistrate, douchebag. Pretty much the same thing.
Okay. So if the judge is supposed to rule on the motion to dismiss beforehand, will they notify me, or like how does that happen? Will they say your motion to dismiss has been dismissed? Like, how do I know going in where I stand?
Well, they should give you, if they are going to make a ruling on it, they are supposed to send it to all the parties. And so they should. So if he's just going to he or she blanket denies it and just says, they're supposed to give you notification of that. And one of the reasons for that is you have to have the information necessary to effectively defend yourself. And so there are legal implications when they deny a motion. And so if they deny a motion to dismiss, they need to notify you because you have legal recourse to challenge that. So you're able to get that reviewed in a higher court, and you can stop the trial. And they know that. So a lot of times that's what they'll do is, well, not a lot of times, but what some scumbags do is they will reserve their decision for the day of trial, which works to deny you any kind of review remedy. That is your classic scumbag lawyer move. I'm not going to rule on your motion until the day of trial. Like, wait a minute. What if you're going to grant it? Yeah. But that's the thing. We're not going to. And you see, because they know these things, they are deliberately obstructing justice because they've taken away your remedy to file a petition for a writ. They do it deliberately, and they can do it because there's no one to stop them.
Okay, seems like this is going to be quite a learning experience for me. I mean, it seems cheaper to just pay the fucking friggin' ticket, but you know, just the principle of the whole thing.
Yeah, well, sure. Some of us do have principles and want to do our best to live consistently with that. None of us are 100%. Of course not. And anyone who says that they are lying. But try to get it done telephonically. It does, it's a one pager. It doesn't take much to write that up.
Well, I'm trying to plan a trip to Utah anyways and make a stop there. And on my way to Utah on Friday for the week after, I mean, if that falls through, then obviously I'm not going to drive down there just for this trial. But that's what I want. That's what I'm planning to do. But so I will try to do that if other things kind of fall apart. But this might help me kind of make this trip to Utah as well.
Okay.
But I wanted to comment. I remember you last year talking about this is not easy. It's a lot of hard work going up against the system and fighting these criminals. You're so right. It's very time consuming. I mean, the amount of hours that I've had to put in on all my different court dates the last few months, just editing the motions and, making sure they're correct and filing them and preparing and listening over and over to your shows and figuring out what I'm going to say and mentally rehearse everything. This is grueling stuff. But I mean, if we just bend over and let them, as a majority of the people do, they're going to keep on doing this. It's got to come to the point where, this is like basic theft, like you talk about. These guys are just friggin' criminals.
Yeah.
And we're trying to do the right thing, and it's costing us a lot of. It's costing me, I know for sure. I'm sure anybody else and other people I've talked to, it costs us a big part of our life to defend ourselves.
And it's by design. If you go through and you read that case, U.S. versus Carter, that decision that I'm talking about, that investigation alone had to have cost $500,000 to $2 million easy just to investigate what these prosecutors were doing, and the mess that it has caused. The mess the public defender's office has. Not only are they defending people, every day from regular from charges, but now they've got hundreds of habeas corpus lawsuits that they have to prosecute also. Just because a bunch of scumbag attorneys cannot play things straight and ethical. So it's definitely by design, because the wealthy, the ruling class, even if they are charged with something like this, they just have teams of $500 an hour lawyers take care of everything for them anyway. It's not like they are personally involved in these things. So all by design, but I'm doing what I can to dedicate the time to help with the role playing. So hopefully this after the next Wednesday show, let's say on Thursday, we can have another role playing session. So I definitely recommend that you participate in that. That should help, and so it doesn't feel as grueling. Okay.
Yeah. Have you had any success in Idaho, or have you helped any people out here, or is it just like any other American court?
I've had success and failures in all 50 so-called states. I've had success and failure in Canada, Australia, New Zealand, and England. So Or some, look, I don't know if some areas are worse than others. There certainly are judges that are worse than others. There's no question there. But some places seem to be a little worse in general because for like traffic, they actually can put you in jail or prison for traffic. Like Florida is one of those. Florida, you know, so
Wow.
so yeah, prison for not having a driver's license. It's insane. So, but yes, there has been success and failures, of course, in Idaho, and unfortunately, with a lot of these things, look, just like this U.S. versus Carter, if another judge had pulled that case, none of the abuse of the U.S. Attorney's Office may have come to light because they just happened to get a judge that decided to apply the rules to a certain degree. Not always the case. So unfortunately, going into court can be a crapshoot. It depends on who you poll, and then it depends on what time of day you're seeing them. That's also been shown. So, but
now, this is at an annex. Like I looked up the Jerome Courthouse, which is about a block away, and this is the county or the district, 5th district courthouse annex. I don't know what that means. I'm not familiar with U.S. district.
I think that's
like
just
some
the
kind of another
building.
kangaroo court.
Well, it's always going to be that. I just think that's the name of the building that it's in. I don't think it has any bearing on what you're going through. So, but hey, you got some time, and if you want to do it telephonically, shoot me an email. I may have a template to help you out with that.
Awesome. Okay, thanks, Mark.
Appreciate the call, Mac in British Columbia. I don't know how well brown skin and a mohawk is going to work in a Jerome court, but they bully everybody. They hate everyone, not of the ruling class equally, probably. Was that line from Full Metal Jacket? I am not a racist. I hate you all equally. Looks like we got a new caller here on the big show. Area code 785. You're live on the No State Project. What's your name? Where you calling from?
Hey, Mark, it's Paul from Florida. I'm just calling on a different line today.
Oh, Paul from Florida. All right. So since you're on a different line, does that mean you have good news?
No.
Okay.
I was just, you answered one of my questions there in the chat, but I wanted to fill you in and maybe you can give me a little bit better direction. This is the third judge going over a year now on this so-called driving on a suspended license case. Two of the judges have recused themselves. The thing is, when I address they won't address the underlying issues on the actual motion to dismiss. They just dismiss a blanket dismissal, saying you got all the you got all the discovery, so-called. They give me a copy of the ticket, my driving record, and some of the statutes, and I still go back to ask them, okay, please show me or tell me how this proves that the laws apply, and they will not answer the question. I think that's why they're so quick to recuse themselves. But now I have a court date now on the 3rd of September. So I didn't know if I needed to take those issues out of the motion to dismiss and just put a motion in just addressing jurisdiction, or what is going to be the best way to approach this third judge, I guess.
Well, do we have any indication in the record that goes to why they recused themselves?
No, they just, last one did it really quickly. I mean, within like 2 or 3 days of when I sent in the request, boom, I got the paperwork back,
See, if it was a matter
they just recused themselves.
Yeah, see, if it was a matter of as in some places, different judges do the arraignment and another judge does the trial, it would involve recusal. Okay, so you're talking about the judge who was assigned to do the trial has recused himself. I would, just like I mentioned in the chat, I would refile what I mentioned earlier. I would refile, but indicate in there that the judge has recused themselves from bias and prejudice, and not, and because it's shown because they're avoiding what you already mentioned. They're avoiding the key issue in the motion to dismiss, and they will not address the missing evidence. They keep misleading you, and I think that's the key to their recusal. They are deliberately trying to mislead you on the record, that there's nothing in the record And hold on. Yeah. You're still there, right?
Yeah, I'm still here.
Okay, good. Oh, I thought because there's nothing in the record as proof of this foundational claim. They're saying it's there, but it's just a way of covering up the prosecutor's lack of evidence.
Okay. I don't have much time to file this paperwork, so.
Well,
Well,
you still have over a week.
Right. I'll get it done.
And definitely prepare to confront the prosecutor and judge on the 3rd.
Oh, no, I'll go through all the judges here in Brevard County if I have to. So, I mean.
Well, hey, maybe after all this.
I think they don't want to address the issue, you know, once it goes to actual trial. And that's why they're so quick to recuse. So I don't know for sure, but
it could be, and maybe after these recusals, there's a wink and a nod to the prosecutor not to have the cop show up, so you can go through all this trouble and the cop doesn't show up. Because bottom line here is the issue is not going to go away and shouldn't go away if you're doing it effectively, because you have to hit the prosecution's witness with this issue right out of the gate in cross-examination, because what was going on in his head that led him to make those determinations and make that stop are proper subjects for cross-examination. And we already know in only 2 instances that have ever been reported to me, Paul, that where when you ask for the facts that the cop relied on for the foundational claim of jurisdiction and probable cause, they will not allow you to get an answer to that question. They'll impeach their own witness. So the issue should not be going.
Yeah, no, but I already impeached him in the very first go around, but we're still going at it. So,
well,
I don't understand why I'm still going, but
well, then you need to, if that's the case, then you need to put in there that the prosecutor is knowingly. The prosecutor and each judge is knowingly relying on the witness they said was not qualified. That needs to be put in the motion to dismiss.
So I need to put all that in the motion to dismiss.
Oh, yeah. It's basically also taking the information from the motion to dismiss for prosecutorial misconduct, which is probably the better way to go at this point. And so I can send you that template. So email me after the show, and I'll send you that template. You need to have in there what happened, what was said, what their objection was to his competency and credibility, and that they're still planning on using that, and that is textbook prosecutorial misconduct.
Okay.
I will do. That's important information.
I appreciate all the help.
No problem. And hey, keep in touch. I'll get you that template after the show.
Thanks, Mark.
All right, appreciate the call. It's Paul in Florida. I'm going to drop off the call line so I can take these stupid headphones off. That's this is more evidence. I'm sure that if a study could be done, if you can get reports from people, that you would see that every prosecutor's office, not every prosecutor, but every single prosecutor's office in the United States engages in regular prosecutorial misconduct. How Mike Randall in New Hampshire, thanks, Bill, for reminding me of that name yesterday, knowingly putting a state employee on the stand, making an offer of proof when he knew full well that witness didn't have the evidence. How do we know that? We had been asking for the evidence for years. And no, prosecuting other people and putting them in jail is not evidence a written instrument applies and creates obligations on you today. Not how evidence and logic work. Not in this universe. So here Paul has already gotten an impeachment from the prosecution and the judge that the witness isn't qualified or competent, and they're going to rely on it anyway. Imagine for a second if you and I try to do that same deal. Once again, the little people. I have my Ireland shirt on today, so that just goes to the whole historical basis of the Irish not being, not being, equal, not being on the same level as everyone else. Gosh, I got to address this. William is saying, Mark, this goes back a while, but I wrote it down. I did not want to forget this. He says, Mark, how do you continue on all these years without being angry? Well, I have spent some time being angry. I've actually gotten severe criticism for it, because when people are being abused, it's just that most of the time I'm not angry. I'm not an angry guy. And but when you hear what's going on and what is happening to people, when you see someone like Ken Anderson, who deliberately put an innocent man in jail and then lives a life of absolute immunity and luxury, have no accountability whatsoever, it gets to you. So I'm not an angry person, and I don't fly off the handle much, but there are times, and I've done shows where people just turned it off and said, I don't want to hear this guy rant. And I understand that. I get that. But there are things, if you have principles and you try to live a principled, ethical life, things are going to get you upset. We hear things like Dick Noble, for example, putting people in jail for 60 to 90 days for asking a question. And then once he knows that the court is moving on a habeas corpus, they'll let him out. He knew that there was no justifying putting someone in jail for asking a question. Because even if there was jurisdiction, you don't put people in jail for asking a question. You can have them removed from the court if they're being disruptive, but jail? 60 days? I tell you what, you can start. I could accept putting someone in jail for 60 days for asking a question if every time a prosecutor committed prosecutorial misconduct, you put his butt in jail for 60 days too. How about that? How about when a U.S. attorney gives a sweetheart deal to someone trafficking in children, a child molester, that every time they do that, they get at least 60 days in jail. They give them a sweetheart deal and blanket immunity. Put them in jail. But you see, we've got a small group of people who people believe and act as if they believe that they have a moral right to do what is immoral. That ticks me off. But it doesn't profit us much to just get angry. You got to actually do something, like they're doing up in Hong Kong. They're actually doing something. But I tell you, like I mentioned a bill yesterday, if they really wanted to wake up Beijing, if they really wanted to send a message, and I'm not taking away from what they're doing because it's obviously having an effect, because they're calling the tanks in. But let Beijing and Hong Kong know, if they do not do X, Y, Z and allow them to be human and to be people, they're not going to pay taxes. That'll get their attention. Let's see, Mark, can people cage the judge? Claim golden rule, just saying. Oh, the golden rule is to do unto others as you would have done to you. To treat others the way you want to be treated. And if a judge is actually hurting people, I have no moral or ethical issue with self-defensive force. So if the judge is hurting people, put him in prison to keep them from hurting people. It's an exercise of self-defense, but there has to be evidence. So I don't have a problem there. So anyway, I'm going to wrap up here now. I think, so I do, like anybody else, things do tick me off. It's just, I'm not generally an angry person. So if you go back, if you want to see it, I get angry enough times, but I want to see some more productive things. Sometimes in the heat of the moment, you get a little, you hear something and it just ticks you off. But generally, I'm not an angry person. So If I was, whoa, I'd probably be in jail because you can only take so much of this abuse before you explode and choke a bitch out. So, but we talked about that enough. Appreciate everyone tuning in to the big show here today. I'm glad to be back on a regular schedule. Really glad that we had no tech issues, just a little minor fudge at the beginning, but so hopefully we'll start getting more calls again. So if we missed anybody today or you were late, whatever, any questions or comments that you have, we will be back live on Wednesday. And so remember, the Epstein case should not go away. It should always be front and center. We should be talking about this because it goes to why we're anarchists, why we want to get rid of the ruling class, and that having a ruling class is immoral and it's dangerous. It's extremely damaging. And the Epstein thing is just one example. It's not an isolated incident. It's a very common thing with politicians in the ruling class. They seem to have a real taste for kids. The Franklin affair, 30 years ago, front page news at least one time. The Jimmy Savile case, right there, everybody knew about it. The industry knew. They knew about him. That ticks me off. And then, of course, the Dutroux affair, so many people knew. And they just keep trying to cover it up. So let's not let this leave, our attention. They're going to keep getting away with it unless we do something about it. So let's get in front of these city councils. Let's start making some ways and start questioning and exposing these people as the criminals that they are. But till Wednesday, when we're back live, salud.